kind of a go-get-em kind of activist type. And she was writing a book, I remember. She was writing a book, or he was writing a book, rather. And I had a house on one of my, on Sweetser, one of the houses there was empty. And it was in fact a house that I'd set up to write in. And when she had no place to stay or whatever, I called her over and I showed her the house, you know, where the desk was and all the things. And so I said, write your book, you know, write your book here. So she did.
Did Io end up living in that house or just working there?
No, Io ended up, no, she ended up living in the house for somewhere in the neighborhood of a year, I guess. Somewhere about a year.
And how much rent did you charge to Io?
Nothing.
And did there also come a time when Rocky moved into the penthouses at the Eastern Columbia building?
Rocky moved into Penthouse 2.
And do you recall when that was?
Oh no, Penthouse 1, sorry. Penthouse 1. That was not long after Miss Heard and I started to begin to dress that place up as our residence. So it wasn't very long after that at all that Rocky came. I had already had my friend Isaac, who you've met, Isaac Peruch, painter. I had already given him Penthouse 2 to stay in and live in and paint in, because he'd just come back from Florida, and his mom had passed away, and I think he had about $3 in his pocket. So I gave him the penthouse and asked him if he had enough paint, and so he lived there.
Why did Rocky move into the penthouses?
Projection foundation.
I'll overrule.
And hearsay. Question potentially calls for hearsay.
I'll overrule that.
Why did, sorry, what was it again?
Why did Rocky end up moving into the penthouses?
She ended up moving into the penthouses. I don't recall. I believe it was something to do with just not having a place. And Amber had asked if I would be okay with, you know, Rocky moving in. And I said, of course. I said, the penthouse is empty. I wasn't in the, I wasn't going to be renting them out necessarily anyway, you know. They would, for friends to come and stay. Penthouse 4, in fact, was initially planned out for my sister Christy to have an escape from her 3,000 grandchildren and the amount of workload that she had taken on at the company.
How long did Miss Pennington end up staying in the penthouses?
Longer than I did.
And how much rent did you charge to Miss Pennington?
Nothing.
Did anyone live with Miss Pennington in the penthouses?
gotta
Yes.
continue to build and build.
her fiance, or boyfriend and fiance Josh Drew.
Oh, shit.
And at a certain point, I learned that there was
I dropped the brush and
another female living there who I wasn't sure who that was. I didn't know who it was. Because there were 2 bedrooms. And so she had invited a friend to move in. But I met that person very briefly a while after they'd already been living there.
All right,
Yes,
good.
I think this is a good stopping point.
That's fine. All right, ladies and gentlemen, it is 5 o'clock, so we'll go ahead and break for the evening. Again, did not discuss the case with anybody and don't do any outside research, okay? We'll see you early in the morning
cool guy.
at 10 a.m., all right? Thank
Oh,
you.
yeah. Cool
Your excuse
dude.
for the day, thank you.
You know, I thought that he would be more, it's like,
And again, sir, since you're in the middle of your testimony, do not discuss your testimony with anybody to include your attorneys this evening, okay? All right, you can stand down. Okay, thank you. All right, is there any other matters for this evening? Sure, sure.
I have to get the other brush and build this up, figure out how I'm gonna make this painting. I'm gonna have to figure out, well, I did that, came out, it's still pretty stuck. No, that was supposed to be the, no, what the hell was looking like that? Yeah, I did that. Yeah, that was supposed to. So, let me, hold on. That's it, right? Let's say I do that. Let's say I do that, right? Let's say.
Mr. Depp, I'm going to play another audio recording. This is a different portion from what Mr. Rottenborn played for you today. It's DX 598. I believe the portion Mr. Rottenborn played was designated 598B, so this will be 598C. And first I'd like to play the portion from 31 minutes, 14 seconds to 33 minutes, 4 seconds.
Any objection to 598C?
And then we will go on and play the second portion, which is 56 minutes, 27 seconds to 59 minutes, 54 seconds.
All right, 598C in evidence.
I don't know.
You know, and it builds, right? Like you build, I build, you know. It isn't like at one moment either of us sign a certificate of saying, or like sign a contract or say, okay, now I'll blood bath. No. So acting as though there's a choice between the two is irrelevant. I'm not asking you to stay over having a bloodbath. I'm asking you, over walking away. I'm not asking you to have a bloodbath over walking away. I'm asking you to work it out over prolonging it and making it bigger.
Right, but if,
At least that's how I see it.
indeed,
You know?
but if things get heated,
Yeah.
and it looks like it's going somewhere nasty, and the name calling begins, and all that stuff, I've got to get away. Because I don't want to be ever in a situation again like that. Never.
Me too. Me too.
Never. So
Me too.
that's, don't freak out if we do have a fight and I walk away.
I'm not going to do that. I'm asking you to stay when you feel you are also in the interest of working it
I
out.
think it's a good idea for us to take a moment or two, or I mean a moment, and take some time. Take some time to think by ourselves without being, you know, barraged by each other's fucking bullshit whatevers. Let's take a break from it, and then come back, try and be calm, and walk through the thing. But I'm not gonna stand and fight with you. I will not. You can call me a coward.
I don't
You
want
can call
that.
me anything you want. All those names, do it. But I will not do it again.
Please stop asking. I mean, please, can you stop for the sake of this conversation?
I'm just saying I won't do it again. That's all. Okay, great. Then let's take our space, and let's not do this anymore. Because I'm really getting frustrated. And I'm really, really, really sick of this argument.
Sorry.
Okay? So let me go, and you go, and I'll speak to you in a couple hours. Okay? Okay? Why are you saying stop? May I go?
Please, it causes me so much stress when you walk away from me with that. It's like you don't understand how much worse you're making this.
I can't believe this.
Please, you're making it worse for me.
Okay, I'm sorry for you.
Please, I'm only trying to tell you so that you know you're causing me immense stress right now when you walk away like that. There's no reason to be mad.
Well, then say goodbye. I haven't walked away. You're not saying goodbye. You won't let me fucking leave. Let me leave.
Stop rushing me! Stop pushing me in the corner and then poking me with a stick and then saying, why are you saying the words you want me to say? Stop poking me! Stop rushing me! Stop throwing me against the wall! I'm going, what? You don't like that wall? You don't like the fucking wall? Stop pushing me!
I'm not pushing you. I'm rushing you. I said, I need space. I don't want this conversation anymore right now. I need space. And I will take my space. Whether you like it or not, I will take it. And you will take your space. But if you keep halting
I'm not doing anything
this
to you.
and continuing
I'm not
with the rhetoric,
doing it. I'm begging you to stop.
I don't. Okay, stop. I'm stop. Stop. Now I have to go. Okay? So we will speak to each other in a couple of hours. Okay? I'll give her some kind of revelation makes you feel better. You know? I hope I do too. But we'll just see when I get home and we'll just talk, or we won't talk, or we, you know, we'll finish this, or we won't finish it. But this is not, well, this is not happiness. This is not, this is,
Please stop doing this. Please, you're causing me so much stress. I'm gonna die at this age. I'm gonna fucking die. You're causing me so much stress. Please stop. Please, I feel like I have a heart attack almost every day. Please stop. Please
And what do you-
stop
why-
doing it. Please stop being so fucking mean.
Why
You're
are
a
you
fucking
with me?
bully. Stop. Please stop. I've been begging you not to fight. I just said, can we please have a normal argument? Just even a normal conversation, like a normal argument. And for the last hour, I've been begging you to please just leave it at that. Let's just go on with our night. I would have been able to come in with you. We would have been able to let it go in a few minutes. It would have been fine. It would just, if we allowed ourselves to have fucking normal arguments. Please, you're killing me with this. You're killing me. You're fucking killing me. Fuck.
Sean, could you, please, I want you to just go, I want you to take your medicine. I or whatever. I'm sorry that I've upset you
Yeah, I
this
think-
much.
Thank you, Sean. I'm ready to go. Thank you so much.
I'm ready.
Mr. Depp, in the beginning, well, first of all, do you know where you are when you're having this discussion with Ms. Heard?
The only, excuse me, the only clue that I have is that Sean is being called. I called Sean and said to drive her home, or I believe it was probably at Sweetser, so then she could drive back, he would drive her back to downtown, House 3, with, she didn't seem in any shape to drive to me.
And earlier in the clip, there was a reference to a bloodbath. What does that mean in the context of that conversation?
I don't know. Again, it seems like some word that was, it became
Objection,
part
Your
of it.
Honor, he said he doesn't know.
All right, I'll sustain objection. Next question.
Mr. Depp, at the end of the day on Thursday, Mr. Rottenborn played an audio recording for you where you were hurt saying you were going to hurt yourself. Do you remember that?
Yes, I do.
Okay. And I'm not going to play that audio recording again. It seemed upsetting to you, but I do want to ask you a couple questions about that, okay?
Sure.
Could you please tell the jury when that recording is from?
The recording is from July 16. This was a few months after the restraining order had been put on me. I had been on tour through Europe, and then coming through the States, I got messages from Christian Carino, who was both of our former agent, saying that Ms. Heard wanted to meet with me in San Francisco. So the things that he asked me if I would. Our last dates on the tour were in San Francisco. And I was confused as to why. The film, and I had met, already met a number of actresses, especially since I was under. And so what I said to Mr. Robinson is, I don't know how. Yeah. 2 and 8 figures. I don't remember. I remember. First I reacted.
Objection, Your Honor, the question was simply, do you remember when that was from?
I believe.
You asked him.
In Los Angeles, yes.
So, where were you when that recording was taken?
Whitney and I had, that was in San Francisco, down at a hotel room. Line into cocaine. So we went to a hotel room so that we could finish the discussion that she wanted to have with me.
And how did that discussion go?
Not particularly well. I was quite confused as to why I had been summoned to her at that point, since all the news was just about the fact that I had allegedly done all these horrible things to her, and so I was talked.
What is this? Uploaded. FBI testimony data. Accessible. What is it? Admissible against suicide.
New orders in the Durham prosecution against former Clinton campaign lawyer Michael Sussman. You can see Judge Cooper issuing this on April 25th. It's 6 pages long. We're going to go through it. It's addressing 2 pretty important issues: whether certain evidence can be admitted or whether it's going to be precluded, kept out of the jury's eyes, and number 2, whether a witness can testify. In this case, very important witness, guy by the name of David Martin. You can see supervisory special agent. We're going to learn more about him. And we're also going to hear from Judge Cooper throughout the order as he's explaining what type of evidence must be precluded and what type of evidence can come in, what evidence the jurors can hear. The big order starts like this. Defendant Michael Sussman, seen here, we talked a lot about him, charged with 1 single count of lying to the FBI. And this is a very important concept, this concept of being a material lie, because this is a legal term of art that they've been fighting over for quite some time. It's okay to meet with the FBI and talk to them about certain things, but you can't say things that are dishonest, that are lies. So we got to be very clear about what that conduct is, what type of language constitutes a lie, what is material, what's not. So we'll see what that means as we go through this order. The charge arises out of a September 2016 meeting between Sussman and the FBI. And remember, that's in the months leading up to the election, gigantic election between Trump and Hillary Clinton. Sussman working with Perkins Coie, Mark Elias, and they were working to create this fake narrative that would help get them an advantage during the election season. Sussman goes, he meets with the FBI General Counsel James Baker, a lawyer, knows better, during which time Sussman provided Baker with 3 white papers and associated data files saying that he would substantiate a reported link between Russia's Alpha Bank and Donald Trump's presidential campaign. Sussman shows up at the FBI's doorstep. I've got the goods. I've got documents here going to show that Trump and Putin are in bed together. Here's the connection through Russia's Alpha Bank. False statement charged in the indictment because he showed up there and he told the FBI, I'm not here on behalf of anybody else. Then he turned around and sent Hillary Clinton a bill for it, literally. False statement charged in the indictment does not relate to the substance of the shared material, but rather to Sussman's alleged erroneous statement that he was not attending the meeting on behalf of a client. Sussman saying, I was just wrong about this. The FBI, Durham, the government saying, no, you lied. You knew better. You're a lawyer. You were there on behalf of the Clintons. You helped concoct this entire narrative, and you showed up and said otherwise. The order continues from Judge Cooper, says trial is set to begin next month. In May, we're ready for it. The parties have been filing a bevy of pretrial evidentiary motions. We call these motions in limine to address preliminary issues, get all this stuff sorted out before you're sitting there in front of the jurors and you have to kind of go through this right in front of everybody.
Everybody's going to want to take deals.
Do most of this outside of their eyeballs. Here, the court writes, at Mr. Sussman's request, the court heard expedited argument on 2 issues that bear on the preparation of the defense. So the defense Sussman's team says, Judge, we got to really resolve these issues so that we can better prepare our defense. Because if it goes this way, we're going to do this. But if it goes that way, we're going to do that. Here, 2 issues. Number 1, whether Sussman can preclude evidence about the accuracy of the data that he gave to the FBI. So let's break that down for a quick moment. Remember, when Sussman came to the FBI, he had a bunch of documents. It was the Steele dossier, 3 white papers that the court referenced earlier, and he's saying, okay, well, I showed up with those documents, but we can talk about that to the jurors, we can show them the document, whatever, all of that's fine, but I want any conversation about how I got those documents, where they came from, the gathering or the accuracy of the data, what's in those papers, how we got that Steele, all of that, I don't want to talk about any of that. And he's going to make the argument, well, it's not relevant. I don't really think that the jurors should hear that.
It isn't relevant because it proves
it
that
really has no
it's
bearing on
bullshit.
the actual conversation
That's
that
the whole
Sussman had with the
case.
FBI, whether he lied to them or not. Well, the documents are sort of irrelevant.
He ain't- he
The
ain't
lie
never-
is not about the documents. The lie
No.
is about whether he was there on behalf of Hillary or not. Turns out he was. As a defense attorney, one of the reasons why you might want to keep that information precluded would be if
To
you're a
protect
juror
Hillary.
and you got information that showed that there was a massive conspiracy, that all these people
Yeah.
were working
Of
together,
course you
and
wanna-
you heard about Steele and you heard about all of the different connections with Perkins Coie and Mark Elias and how everybody was involved in this, you might take a look at Sussman and go, well, you're just the frontman for a gigantic conspiracy, and you might attribute all of those nefarious acts onto your own client. And so you might want to protect against that if you're the defense. same sort of works in reverse if you're the prosecution. You want to show all of that. You want to say, yeah, look, this isn't about
Yeah.
a guy named Sussman who showed up just with a stack of papers and said, oh, golly, I don't know what's in these white papers, but I guess I'll turn this over to you, FBI. And they say, are you here on anybody's behalf? And he says, no. And they go, okay, well, that makes sense. Prosecution's going to go, that's a ridiculous story. That's nonsense. What we're talking about is a gigantic conspiracy, a hoax, a big group of people working together to derail an election and create a fake narrative that would further their political objectives.
Yeah.
They want the jurors to see all of
All
that.
of
The
it.
defense, of course, doesn't. So
Doesn't
they
want.
filed a motion to preclude that, as well as another motion to exclude the
Yeah.
government's proposed
That's not
expert
gonna work.
witness, this other special
That's
agent
not
from the
gonna work.
FBI,
I
who's
doubt
going to
it.
come and do the same thing. The prosecution wants him to come and talk about all the details and technical data to show why this whole thing was ridiculous. And the
And who the
defense
hell-
doesn't
who
want
else
that to
knows
happen.
how
They just
far-
want to
how
say
far the
that
rabbit
old
hole
Sussman
goes
was just a
in the-
confused,
if
good
Obama's
citizen, was
has
there with a
something
big
to do with
dossier and just wanted to turn it
Oh
over
my
to the
God.
FBI. The whole thing's a
That's
big
gonna open up a
misunderstanding.
can of
He just
worms.
wanted to help. And if they are able to limit the extent of his back-end operations, that's going to serve their cause. Durham, of course, wants them to see all of it. The judge writes, as explained below, the court will grant in part and deny in part each motion. Two motions from Sussman, one to get the
Wow.
data out, number two to keep the expert witness out. Some granted, some not. So let's break this down.
Wow.
Judge Cooper writes, the court also reserves certain issues for further evaluation after this week's hearing on the remainder of the evidentiary motions. And we know this is coming up. We have oral arguments scheduled later in the week, which of course we'll break down. We jump into the order, Section A, motion in limine on the data. This is the argument from Sussman that anything that is in the white papers or the dossier or what was presented to the FBI, he's saying should be precluded. It's not relevant. It has no bearing on what the conversation was between him and the FBI and whether or not he lied to them. He says the court begins here with Sussman's motion to preclude the introduction of the evidence about how the data he provided to the FBI, the dossier, how it was gathered, whether it was accurate, and purportedly related information in the dossier put together by the former British intelligence officer
Wow.
Christopher Steele. So he says, we're talking about this issue, let's be clear. The court will reserve judgment on much of this motion, so I'm not going to issue all the details right now. He says many of these issues are linked closely with other motions in limine which haven't been argued yet. We know that many of those are coming up this week. But he writes, however, whether and to what extent the court will allow in evidence about the data's accuracy bears directly on Sussman's request to exclude the government's proposed expert testimony. In other words, these two things relate to one another.
Yeah.
Here, the data and the accuracy might be something that that special FBI agent is going to testify about. So if we're going to talk about some of that data, we may need an expert witness to come out and explain the data. And if we don't have that data coming in, well, we may not need that expert witness. He says, with respect to those issues, the court will grant the motion in part and deny it in part, although it again reserves judgment on certain issues. And many of you have followed along on some of the other trials we've covered here, cases like Kyle Rittenhouse and Ghislaine Maxwell and several others like Derek Chauvin, where you'll see the judge will sort of say, I can't really rule on that yet because I have to wait until the questions and the line of questioning, the
Yeah.
inquiry develops a little bit,
Yeah.
and then we'll start
Yeah,
issuing
they
some
can-
rulings.
yeah.
Judges have different styles on how they handle these things,
Yeah.
but here you can see the judges allowing a sort of a loose framework to be created,
Yeah, yeah,
saying
yeah.
he's going to reserve judgment for certain
For
issues.
certain issues,
Continues
yeah.
on, says, the court begins with the parties' concessions. And here we talk a lot about the scope of the argument and what is included in the argument or what is excluded. And oftentimes we see that different sides will fight over that. They'll fight over the scope of the argument. The judge is using similar language here, saying, there are different concessions here that make my analysis easier. Writes, this narrows the field of play significantly. We don't have to argue about a bunch of stuff if you're willing to say we're not going to talk about this and you're not going to talk about that. He says in its opposition brief, the government explains that should Sussman, right, he means Durham is saying, should Sussman, quote, concede or decline to dispute the fact that no secret channel of communication actually existed between the relevant computer server, Trump, and Alpha Bank, then Durham is not going to even seek to offer proof concerning the accuracy or the reliability of the data. And he's referencing this right from the government's motion, their opposition to the defendant's motion. This is what they responded to when Durham said, we want to keep all this data out. Durham said, look, we are okay to not even offer proof of the accuracy of or the reliability of that data if you're willing to say, or not going to dispute the fact that there was in fact no actual channel of communication. So both sides are kind of taking this out of the argument. The government is saying if you acknowledge there was no direct connection, or you don't make that argument that Trump was in fact communicating through Russian banks called Alpha Bank, then we're not even going to argue that. We don't have to talk about it. At the hearing, the defense counsel stated that they will not seek to affirmatively prove the existence between Alpha Bank and Trump campaign, which makes sense because they can't prove that. And they're not going to try.
Yeah,
And
but
so
you need to
the
find
government
out.
in Durham and his prosecutors are now saying, all right, well, we're not going to try either. If you're not going to try to prove that, we're also not going to try to prove that because that's not really what the point of this case is about. With that representation, the judge is acknowledging both sides are giving a little bit here. The court will hold the government to its word and will not allow it to put on extensive evidence about the accuracy of the data Mr. Sussman provided to the FBI unless Mr. Sussman does so first. And I think this does make sense. If the charge here, the indictment, is lying to the FBI, remember that the real portion of the lie that we're talking about, that actual conversation, wasn't necessarily about Sussman delivering a dossier filled with lies. It was the fact that he was there communicating to the FBI, saying that he wasn't doing that on behalf of another client. That was the lie. It wasn't that the dossier was full of garbage, which we all know it was. It was that he was there saying, I'm not working for the Clintons. So we got to make sure we're sort of teasing out those issues. The judge is saying, yeah, the dossier, I'm not issuing a ruling, or we're not even going to argue about the accuracy of it. It may be accurate or not, who knows? The judge says that's not relevant. The indictment said he was charged for lying, so we're going to stick to that. Judge Cooper continues, says that does not end the inquiry, however, as the parties disagree now about, number one, what remains of the government's data-related evidence. They
Okay,
still
I
got
see
a
what
lot of
they're
it.
saying. So,
Durham has USB drives
we're
out the
gonna,
wazoo.
the case is
And number
about that
two,
he's
what
lying,
Mr. Sussman
not so
could
much
do at
about the
trial
dossier.
to put the data's accuracy at issue. And so the defense is now
But
saying, well,
then-
Judge, this is a little bit of a precarious position for us to be
If
in.
it's about the
I mean,
dossier.
what if we just go down a general line of
And that
questioning
he
and
was there
somebody
on the
says
behalf of
something and
Hillary
the prosecutor's
Clinton.
over there say, oh, boom, bingo. Now we can get to use all of that external data.
It's
We get to
bullshit.
bring that in because the defense opened the door. They sort of, made a mistake and somebody said something and now the government comes back out and says, well, we got to rebut that claim, Judge.
Yeah, we gotta
And now
rebut that
the
claim.
only way we
That's
can do
what's gonna
that
happen.
is with all this external evidence. You can see now the defense is sort of saying, Judge, we don't want to tiptoe around this issue. Help us out. Judge writes, starting with the first question, the court will permit the government to put on evidence reflecting the FBI's ultimate conclusions. So they can talk about FBI agent, anybody, general counsel over there, can talk about the general conclusion. And at this moment, the court understands that to be Alpha Bank and the allegations were unsubstantiated. We're unable to make those connections. Says as well as the particular investigative and analytical steps that the FBI took to reach them. So we see a standard there. Particular investigative and analytical steps. So what did the FBI do to get from point A to point B? Sussman shows up, I've got this dossier, I'm a good citizen, not here on behalf of Clinton, presents all the materials to them, they do their investigation. What steps particularly, and what steps analytically did they take to do and reach their conclusion? Here, he says that is going to be relevant. We can get that stuff admitted into court. But he says such evidence is relevant to the government's theory of materiality, which is why it's coming in. Their theory being that Sussman and his alleged statement that he was not representing a client caused the FBI to handle the investigation differently than it otherwise would have. If Sussman would have been honest and said, oh, yeah, I do have a lot of very important information, but guess what? Darn it, I happen to also be working for Hillary, who's up for election here in about 35 days. Would that have changed how the FBI processed this whole thing? Probably. You'd think so. If you were in that position, you might think, well, that's curious. Now that information might be compromised or tainted. It's less reliable here because Sussman has a conflict of interest. His boss wants to see Donald Trump taken out and would be very gleeful if the FBI came and endorsed this dossier and said, yeah, it is a big problem. They could run with it and go indict him and take him off the playing field, which is something the Democrats like to do. The judge continues, he says, how that investigation ultimately proceeded and the conclusions it reached are relevant to that inquiry. FBI had to make decisions Part of the government's theory here is that
Crazy.
there was a misrepresentation from Sussman about why he was there. That was material to the FBI's decisions in their further investigation. It continues. Judge Cooper writes, some of the evidence the government discussed at the recent hearing, though, does not fall into those permissible categories. So while we can talk about the particular investigative and analytical steps, other things not. In particular, the court will not allow representatives of the companies who maintain the servers that reportedly received communications from Alpha Bank to testify about their involvement with the FBI. There were other people, Fusion GPS or other companies that were maintaining servers. Who knows specifically here, but the judge is saying we're going to limit it to this narrow scope. Those other people just aren't relevant. He says, even though the government thinks they're relevant, he writes, contrary to the government Durham's assertions, says this evidence does not appear to be probative of why the FBI took the steps that it took in their investigation. It doesn't help us determine whether they took one course of action or another. It's not probative or material enough to be relevant that we're going to let it in. He says, and it is at a minimum unnecessarily duplicative of other, more direct evidence of the same. He's referencing a 2013 case from the DC Circuit, saying that where there is duplicative evidence, and we have two things that tend to show the same thing, well, we don't want to just start layering on a bunch of duplicative evidence. Here in this case, we've got enough evidence that Sussman sat down, had conversations with the FBI, and purported to be not there on behalf of anybody else. And so we're talking about that materiality of what his statement and whether or not that influenced the FBI. Here, whether the people who worked on the servers to help him create some of this data, that's not really as relevant as to whether he lied specifically to the FBI. For the same reasons, he writes, the court will not allow extensive discussion of another federal agency's investigation into the same data that Mr. Sussman provided. What other agency is he talking about there? Oh yeah, the CIA, remember them? That's because Sussman went over and met with the CIA after he met with the FBI. Except to the extent that agency's findings and analysis had a direct bearing on the course of the FBI. So remember what the judge is doing again, narrowing the scope. He's charged with, in the indictment, with lying to the FBI. The CIA conversation is sort of not necessary to the underlying base issue. He continues, finally, the court takes a moment to explain what could open the door to further evidence about the accuracy of the data that Sussman provided to the FBI. If the defense does something and they open the door, if they crack that shell a little bit, then the prosecution can just drive a bus right through.
Yeah.
As the defense concedes, as Sussman's team acknowledges,
And
such
they don't
evidence
do that.
might be relevant if the government could separately establish, quote,
Because they want to bring
what
everything up.
Sussman knew about the data's accuracy. So if they can say Sussman showed up there and he knew that maybe the data was problematic,
Yeah, problematic. yeah.
maybe that changes the equation.
That changes
They write, if Sussman knew the data was suspect, evidence about fault in the data could possibly speak to his state of mind at the time that he met with Mr. Baker at the FBI,
Wow.
including his motive to conceal the origins of the data.
Yeah.
If he knows the data is problematic, he says this thing is a hoax big
Little
time.
bullshit.
But if I go and I tell the FBI that I'm working for Hillary Clinton, they're going to go, well, we better really look at this then. So they might find the hoax a little bit more easily. By contrast, Sussman would not open the door to further evidence about the accuracy of the data simply by seeking to establish that he reasonably believed the data were accurate and relied on his associates' representations that they were. So if in the line of questioning, if Sussman takes the stand and they ask him questions, did you know anything about this data? And no, I just thought it was reasonable information provided by our research team and I took it over because I'm a good citizen. That alone is not going to be enough to open the door. But he says such a defense theory could allow the government, if that did open the door, that would allow the government to introduce evidence tending to show that his belief was not reasonable. For instance, facially obvious shortcomings in the data or information received by Sussman indicating relevant deficiencies, but it would not open the door to a lengthy and complex exploration of the underlying data. So just allowing a surface level discussion of that. But not saying, okay, we're going to bring in all of the people who run the servers and we're going to bring in all these special agents and expert witnesses to verify the data. This isn't a trial about the legitimacy or the accuracy of the information. It's about Sussman and his lying to the FBI. He says, I understand these are broad guidelines. Beyond those broad guidelines, the court will reserve any other judgment about the issues raised in the motions about the data as the trial unfolds. Before we get to paragraph B, the second part of this order where the judge is issuing a ruling on whether or not a special agent can testify, we got to learn a little bit more about the special agent, this guy, David Martin with the FBI. And this is a clip from a website where he was giving a speech some time ago, but they have a little bit of a bio here. They say he's part of the FBI's elite investigative rapid response team for computer intrusion incidents. Really, just like what we're talking about here, apparently. A native of Denver, 15 years law enforcement with the FBI, been investigating computer intrusion since 2009. Cyber technical operations, Bachelor of Science, has a lot of different degrees and technological background certifications. His specialties include digital forensics, incident response, network traffic analysis, malware, reverse engineering, and writing ugly, poorly documented field expedient Python scripts, as well as a few more polished digital forensics platforms. He's a joker. He's got a sense of humor at the FBI. I think that's illegal. Somebody should call Merrick Garland. We have more. Paragraph B, motion to exclude expert testimony. The defense does not want him to come and testify. Seems like a pretty reasonable fellow. So the Sussman defense filed a motion to exclude him, preclude his testimony from coming in to trial so the jurors can't hear from him. And the judge now is going to address that, saying, now that we've talked all about the data, let's talk about the expert witness who might be useful in explaining the data. He says, with this background in mind, the court can more easily resolve Mr. Sussman's request to exclude testimony from the government's proposed expert, FBI Special Agent David Martin, the gentleman we just learned about, writes, the district court has a gatekeeping responsibility to ensure that expert testimony is based on scientific knowledge that will assist the trier of fact to understand or determine a fact and issue, referencing another D.C. Circuit case from 2016 and the federal rules of evidence. So he says, the court will largely deny the motion and allow Special Agent Martin's proposed testimony, subject to some limitations consistent with the analysis above. So he is going to be able to come out and talk. Footnote 1 from the defense, Mr. Sussman urges the court to exclude the expert testimony on the ground that the government noticed provided information that he was going to testify untimely and that it wasn't specific enough. Because the court will limit, the judge writes, Special Agent Martin's testimony largely to general explanations of technical data has always been a part of the core of this case, much of which Mr. Sussman does not object to. Any allegedly insufficient or belated notice, he writes, did not prejudice him. The defense is arguing that Sussman got notice that Special Agent Martin was going to testify late and therefore he should be precluded. The judge says, yeah, maybe it was a little late, but it didn't actually harm you, so you're good. Also writes, assuming that Special Agent Martin is qualified as an expert, the court will allow him to testify about 3 general topics. First and foremost, and most significantly, background information necessary to understand the relevant data, including basic mechanics, architecture, terminology, computer systems at issue. We got to learn about those things before we understand what data we're talking about. Second, the type of conclusions that can be drawn from analyzing the kind of data that Sussman shared with the FBI. In other words, if we're going to be saying that Sussman, by communicating with the FBI and providing them with these white papers, was promoting a material lie, something that caused the FBI to make an investigation go one way or another, we got to know kind of how the data might have influenced that. The jurors are going to have to understand that Sussman came with something material or not. If he showed up with a comic book and said, look, Donald Trump's here, he's taking over Garfield. And then they would say, well, you're crazy. Let's see you out, please. Thank you. But if it's a material document and it looks like it was properly assembled and it was purporting to communicate a very severe threat, maybe the FBI would have received that differently. And third, the methods investigators would use to validate or further examine that data. Once the FBI received it, what did they do? All 6 proposed testimony topics listed in the government's opposition brief fall within those parameters. These topics are generally relevant to the theory of materiality that Durham and the government plans to pursue in its case in chief, and expert testimony on those subjects will aid the jury in determining the technical aspects of the case. The court will reserve ruling on any objections to specific testimony, though, until trial. Our final paragraph from the judge, he writes, the government suggests that Special Agent Martin's testimony may go further depending on what theories Sussman pursues in cross-examination or his defense case. So Durham's saying, Judge, look, I know we're talking about limiting his testimony to some degree. It could go out, pretty far, depending on what the defense proffers forward. Consistent with its findings above, the court will allow the government's expert to testify about the accuracy of the specific data only in limited circumstances. In particular, if Sussman seeks to establish at trial that the data was accurate and that there was in fact communications between Alpha Bank and Trump, then expert testimony from maybe somebody named Special Agent Martin could explain why this could not be the case. It would become relevant at that time. But what happens if Sussman and his defense don't make that argument? Well, then it's not really relevant. But if they make that one of their defenses, now it becomes something the prosecution can talk about. But as the court noted above, additional testimony about the accuracy data, expert or otherwise, is not going to be admissible just because Sussman presents evidence that, quote, he relied on Tech Executive One's conclusions. That's Rodney Jaffe.
And whoever
About the
loses
data,
the
or
case, they're
quote,
gonna
lack
have
motive to
pay
conceal
the
information
legal
about his
fees
clients.
and-
As the court has already explained, complex
They're
technical
done.
explanations about the data
These people
are only
are so
marginally
done.
probative of those defense theories. We're not going to just
They're so
dump
done.
code all over the jurors, explaining DNS and IP and UPS and zip drives and all of the different codes. The court will not risk confusing the jury and wasting time on a largely irrelevant or tangential issues. And the judge concludes, for the foregoing reasons today, it is hereby ordered that as to item
Okay,
number
so
60,
I'm gonna
defense
leave this
motion
with
in
you
limine,
all.
this is Sussman's attempt to preclude evidence about the gathering of data. You can see, granted in part
That's
and
fine.
denied in part. Granted
Well,
that you can talk about it,
But
you
I didn't
can
have to clean the
introduce
bushes. I could just
conversations
put them in
about
the
the
bag.
data, where it came from, why it's useful,
And
why
put them
it
in the
might have
freezer.
impacted the FBI, but
We
you're
could
not
put
going to be
them
able to
in
get
the
into
freezer.
gigantic, in-depth exposés about where the
Really don't
data came
wanna-
from and DNS, IP records, all that stuff. Similarly ordered, defense
turpentine
motion, Sussman's attempt to throw out the testimony of the special agent is granted in part, but also denied in part, depending on what the testimony shows or what the defense theories are. If they keep it narrowly tailored and they don't jump off into trying to prove Alpha Bank and Trump were all connected, well, then Special Agent Martin is not going to be able to talk about all of those things. The judge is going to try to keep this train on the tracks, keep the testimony focused about what's charged in the indictment, and we're going to continue to follow it. My question to you, of course, is does this matter in any way? Is the judge's ruling, is their opinion or order going
Put a
to
plastic like this.
lead to one type of verdict, one way or the other?
No.
This is what
Put in
attorneys
the
fight
freezer.
over. These are serious motions and serious issues. Sometimes these are seen as little battles, but they can often lead to victories in the bigger war. So we'll continue to follow this. There's going to be a lot more rulings and more additional motions in limine and responses and replies. We'll follow it all the way to the end. I hope you join us on that journey. I would love it if you subscribed before you got out of here, invited somebody to join us as well, and I look forward to seeing you on the next one. Michael Sussman, motion to dismiss denied. Remember Mr. Sussman, one of the campaign lawyers for Hillary Clinton, brought some documents over to the FBI, said, I'm just a good citizen. I'm just here out of the goodness of my heart to communicate a threat about Donald Trump. He didn't really communicate to them that he was there on behalf of Hillary. He was at a law firm that was representing her campaign. And so he said, Your Honor, this is not appropriate. So the indictment as it was written didn't have enough there to allow criminal charges to move forward, and so he filed a motion to dismiss. We covered that at length. The government, Durham, the prosecutors responded. We had a reply from Mr. Sussman, and then we get the order. You can see on April 14th, a 6-page order came out from the judge. The judge's name is Christopher Cooper, and he issued this order denying the dismissal. So Durham opposed the dismissal. He wants the criminal charges to go forward.
So,
Sussman filed to dismiss them, and the judge is denying that motion. Says here, we get some background. The judge says, last September, a grand jury indicted Washington, D.C. based lawyer Michael Sussman on a single count, making a false statement to the FBI, lied to them. There was a September 19, 2016 meeting right before the election, remember, between Donald Trump and Hillary Clinton, taking place at FBI headquarters. Mr. Sussman, seen here, was meeting with Mr. Baker, seen here, and they had a conversation about this. According to the indictment filed by Durham, Sussman requested the meeting to provide the FBI with information, or back then they called them white papers, and the data files. He said that these are going to support the media reports that Trump is colluding with the Russians. Remember, this whole story came out, and Hillary was sort of under fire for her emails, and we're here in September, and Hillary's kind of going down in the polls a little bit, and so they need this October surprise. They've been concocting this whole thing for a long time, and then it comes time. We have Sussman goes and meets with the FBI, says, I'm going to share with you all of this information out of the goodness of my heart, according to him. But we know now, the indictment claims that Sussman actually concealed from Baker, so the Hillary Clinton campaign lawyer, that he was providing information to the FBI in a political capacity. And we're going to take a look at the notes in the next two slides that came out from these meetings, or the notes that were memorialized from two other FBI agents. Here, specifically, Sussman told Baker, so this guy to this guy, that he was not attending this meeting on behalf of any client, when in fact he was. He assembled this on behalf of two specific clients. You see them down here. We have Rodney Jaffe, tech executive number one, the guy who had this contract, who was sort of able to access DNS records and insert himself into the chain of information so he could see exactly what certain locations were doing on the internet. And these locations, of course, the executive office of the presidency, Trump Towers, Trump Central Park, anything Trump, they were going after. That was one client. Number two, Hillary Clinton in the presidential campaign. He was representing her, his law firm. The FBI opened an investigation based on what Sussman provided, but then ultimately looked into it.